Why do some of the best trial lawyers in New York take notes, written notes, during opening arguments? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so let's say you brought a lawsuit against someone who was careless, causing you significant harm and injury. It might be an accident matter. It might be a medical malpractice matter. And the people whom you have sued refuse to take responsibility. So now your case goes all the way to trial. At trial, after your attorney gives opening arguments, you're sitting in the back of the courtroom watching and observing. And now the defense attorney has an opportunity to get up and give his opening arguments. You will find that some of the best trial lawyers in New York are paying close attention and are sitting and recording and taking notes during the course of opening arguments. Why would an attorney do that? Isn't this all recorded by a court stenographer in court? The answer is, yes, it is. There is a court stenographer, we also call them court reporters, that are recording every single word that is spoken in court. But here's something really interesting that you may not know, unless you're a student of these trials, and unless you go into different courtrooms to observe these trials on a regular basis. So what's the big deal? Why would an attorney want to take notes, his own notes, about something that's going on that his opponent is telling the jury during opening arguments? I'll tell you why. Because the attorney is carefully listening to see whether or not the attorney is making any promises. The attorney wants to record and make a note of anything he tells the jury that he anticipates or expects the proof will show in this particular case. You see, when we get up to make opening arguments, we have to show the jury, right, that you have a valid basis for a case. We have to explain to the jury why we are slightly more likely right than wrong than what we are claiming is true. And now we have to show the jury what the proof is going to show in this case. Now, you will find that some really good defense attorneys likewise make notes in their notebook when we get up to give our opening arguments. Why? For the same exact reason. Because they want to make a notation of certain things that we are promising the jury. We expect the proof to show in this case that the doctor violated the basic standards of medical care, that he failed to recognize this patient's breast cancer, that he failed to do X, Y, and Z. And we will show you that this doctor did not do what he was supposed to. And there was no communication between this one and that one. So we are making certain promises to the jury. And now the defense attorney, or likewise I, am making notations about certain promises that my opponent is making. But why do that if we have the transcript, or we can obtain or purchase the transcript from the court reporter? I'll tell you why. Because now in our own notes, our own handwriting, it's a signal to us that now, after your case gets to the very end, right before we have an opportunity or in anticipation of preparing our closing arguments, I want to go through my checklist. I want to go through and see what it was that my opponent promised to show in this particular case. And if the defense has failed to live up to their promise, now you know what I'm going to do? I'm going to make a note of that. I'm going to circle it. I'm going to highlight it. And now when I get up to make my closing arguments, I'm going to bring that information out to the jury. Ladies and gentlemen, at the very beginning of this case, my opponent stood in front of you and with a straight face, looking you straight in the eyes, promised that he would show you X, Y, and Z. Well, now we've been at trial for more than 2 weeks. You've listened to every single witness. You've listened to direct testimony and cross-examination. During opening argument, my opponent stood in front of you and promised to show you all of these things. And let's take a look. I took specific notes about those things he claimed he'd be able to show you. According to my notes and your memory and your recollection, did he show you and prove any of those things? The answer is no, he didn't. He tried to show this. He tried to show this. Guess what? He totally ignored this. And what does he have to show for it? Nothing. Again, why would we try and do that in front of the jury during closing arguments? Because we want to show that this attorney or the opponent did not live up to his promise. We want to show that we were paying attention, and I want to highlight the fact that he made certain promises at the very beginning of the case. Maybe he overpromised things and couldn't deliver on those promises. For whatever reason, now it's the goal of the attorney, a really smart attorney, to highlight things that are missing, highlight things that were promised but never done. That's why you will find that some of the best trial attorneys in New York take notes during opening arguments. So why do I share this with you? I share it with you just to give you a real look at what really happens, during the course of a trial here in New York. I do recognize you're watching this because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit because you still have questions that need to be answered, well, what I invite you to do is pick up the phone and call me. I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.